this is not a typical situation, especially in that this occurred on the record. I think the judge was trying to do the right thing by placing the offer on the record, but then perhaps went too far in engaging Mr. Brown in a discussion of the offer, engaging Mr. Brown in a discussion of the circumstances underlying the offense, and then we have the lawyers standing by like a potted plant, essentially, and offering just one comment near the end of that discussion. What I would say is that this is suggestive of the fact that everybody thought this was a discussion of the plea offer, that this was not something that would come back to haunt Mr. Brown at trial, that this proceeding in itself was somehow shut off from the regular trial process.
Can I ask you about the language of the rule? Because you say that the language of the rule is broad. But when I look at Rule 410, it says that evidence of a plea of guilty, not evidence of an offer to accept a plea, but evidence of a plea of guilty is not admissible in another proceeding, whether offered for or against the person who made the plea or offer. So we have a situation where this is not a statement that's being offered for or against the person who made the plea or offer. And doesn't that last phrase in the rule limit its application to statements made by the defendant in a classic situation where they're pleading guilty to a crime and they have to lay the factual predicate, and then later that plea is withdrawn?
I've read this rule probably 200 times, and sometimes I think that the latter part of the rule, which says that the statements aren't admissible for or against the person, supports my position, and sometimes, quite frankly, I think it's bad for my position. I think it's an inartfully worded rule.
How